Ready, start. Another factor which weighed with the revenue authorities to conclude that the assessee had discontinued business in India was the so-called admission by the assessee that it had no permanent establishment in India. No doubt the authorized representative had averred in the affidavit dated 22/1/2001 that the assessee did not establish nor had any existing permanent establishment in India. However, the revenue authorities have considered this affidavit out of context. The affidavit had to be sworn in context of the assessee's claim for concessional rate of tax with regard to interest income. Since the assessee had claimed concessional rate of tax, the assessing officer inferred that there was a permanent establishment in India. On account of this wrong inference, the assessee had to swear an affidavit denying the existence of a permanent establishment in India. However, taking this as the base, the assessing officer and the CIT within bracket A concluded that since there was no permanent establishment in India, the assessee was out of business. It is not well appreciated by the authorities below that whether there is a permanent establishment in India or not has to be determined as per the provisions of the relevant DTAA. As per the DTAA, the assessee may not have a permanent establishment in India, but that does not necessarily lead to the conclusion that the assessee is not in business. The assessee can be in business depending upon the facts and circumstances of the case D horse, the permanent establishment which we do find in the present case. Considering the facts and circumstances, we hold that the assessee was in business during the period relevant to the assessment year in question. In light of such finding that the appellant had not ceased to carry on business, the tribunal, though holding income on account of interest on tax refunds, was chargeable under the head single inverted comma income from other sources single inverted comma close and not single inverted comma income from business single inverted comma close allowed set off of the expenses on account of administrative charges. Legal professional fees undertaken by the appellant as business expenses from single inverted comma income from other sources single inverted comma close under section 71 of the act. For similar reason unabsorbed depreciation from previous years was allowed under section 32 within bracket 2 of the act. The department challenged the ITAT orders in appeals arising out of assessment years 1996-1997 and 1999-2000 before the High Court. The appeals arising out of all the assessment years 1996-1997, 1997-1998, and 1999-2000 were reheard analogously and disposed of by the impugned order. Section 37 within bracket 1 inter alia provides any expenditure within bracket not being an expenditure in the nature described in section 30 to 36 are in the nature of capital expenditure or personal expenses of the assessee bracket close which is undertaken wholly and exclusively for the purpose of business and profession shall be allowed to be deducted in computing income chargeable under the head single inverted comma profits and gains from business and profession single inverted comma close and consequently may be set off as loss against income under any other head subject to the conditions provided in section 71 of the act.